defense is given their closing. Mr. Williams, you may proceed.
Thank you, Your Honor. May it please the court, counsel. Theodore Roosevelt said that courage is not the absence of fear, but rather it is the judgment that something else is more important. We all know now, having heard the evidence, that Lieutenant Debra Clayton was courageous. When a member of her community, Takesha Bryant, came to her and asked for help, she took action. Now, while the action she took was courageous, and that in fact is amazing, what is even more striking is something that could be easily overlooked. And that is that she never hesitated. Think about that for a moment. A woman runs up to her as she's loading groceries into her car, and tells her there's a murderer in the store, and she needs help. And Debra Clayton went towards the danger. She didn't do so recklessly. She wasn't careless. She called for help, for backup on her radio. She walked calmly, judiciously towards the suspect, hand on her gun at one point, prepared. She gave lawful commands, and eventually she drew her firearm. What is clear from the evidence in this case is that Lieutenant Debra Clayton took her oath to serve and protect very seriously that morning. And that on the morning of January 9th of 2017, she honored that oath. But it is not her oath, nor is it her courage why she is no longer with us. Debra Clayton is dead because of anger. She is dead because of hatred. She is dead because a man valued his freedom more than he valued her life. And the overwhelming evidence in this case leaves no doubt that that man was the defendant, Markeith Loyd. We have presented over the course of more than a week overwhelming evidence of the defendant's guilt, not only of the murder of Lieutenant Debra Clayton, but of all of the crimes with which he is charged. Now, you've been given 60 pages of instructions. So for the next few minutes, we're going to go through all of the evidence that you heard. We're going to start with the crimes that were committed after Lieutenant Clayton's murder. And then we're going to go back and talk about her actual death at the hands of Markeith Loyd and focus on premeditation, because that evidence will instruct you and give you guidance on how to deal with the defenses in this case. So you all know by now that it is the state's burden, it's our burden to prove each and every crime beyond and to the exclusion of every reasonable doubt. You've been told what the elements of the crimes are, and those are those numbered paragraphs below each and every one of the elements. So I'm going to address a couple of things here because we understand that you're not lawyers and that 40 pages of being read to this early in the morning is not necessarily an easy thing to digest. So the first thing I want to talk about is the lesser included offenses. On following each charge, and I'll use first-degree murder the first-degree murder of Lieutenant Clayton as an example, there are lesser included offenses. And for her charge, the lesser offenses are first-degree murder, and then second-degree murder of a law enforcement officer, second-degree murder. So significantly, you will be given an instruction by the court that you are to find the defendant guilty of the highest offense for which you find evidence beyond a reasonable doubt. So what that means is that you start with the crimes that are alleged and charged, counts 1, 2, 3, and 4, and if you do not find evidence beyond a reasonable doubt, then you move down to those lesser included offenses to see if they've been proven. Now, I'm not going to spend any more time on the lesser included offenses because it is our firm belief that you have been provided evidence beyond and to the exclusion of every reasonable doubt of the defendant's guilt of the crimes for which he's alleged. But that is why you have those lengthy lesser included offenses. It's in the event that there's not evidence beyond a reasonable doubt of the top charge, type crime that is charged. I also wanted to briefly address something with you. And on page 39 of your instructions, there's an instruction about firearms. And if you recall, the judge read the charges over and over and over again. And then there was a line about firearms. What that is for, you will find, is you'll get a verdict form. And at one of those verdict forms, will say special verdict. And if you find Mr. Loyd guilty of the crimes, you'll be asked to find out or make a decision whether he carried a firearm with him, whether he possessed a firearm, and whether he discharged it. And obviously all the evidence in the case says that, but I didn't want you to be confused about that instruction on pages 39 and 40 because it is lengthy. So finally, before we start talking about the evidence, I want to explain to you how the process works briefly and how we're going to go through it. Because we have the burden of proof, we're entitled to split our closing between a first and a second. So in the first closing, I'm going to talk to you about the evidence that we've presented to you that proves these crimes. I am not going to discuss insanity or self-defense much because it is my expectation that defense counsel will discuss that in his closing, and I will wait and hold my response to that until the end. So with all that said, I'd like to talk with you a little bit about the crimes, and we're going to start with the aftermath of the murder of Lieutenant Clayton. Following Lieutenant Clayton's murder, the defendant committed 4 separate additional crimes, one of which actually he was committing at the time that he murdered Debra Clayton. So the first crime is attempted first-degree murder, specifically of Captain Joseph Carter, and that's alleged in count 2. Now, your instructions give you very clearly the 6 elements that have to be proven beyond a reasonable doubt. And I'm not going to go through all of them because some of them are quite obvious. But we'll start with the first one. Markeith Loyd did some act intended to cause the death of Joseph Carter that went beyond thinking or talking about it. So inherent within that element is that we have to prove that Markeith Loyd is the person who did those things, that he's the one that committed the act. Of course, the act being firing a firearm at a law enforcement officer who got out of his vehicle. So how do we know that Mr. Loyd is the one who committed this crime? While Captain Carter did not get close enough or have the chance to get close enough to Mr. Loyd on the day of the offense to actually identify him, he told you what he was wearing. He described his clothing. He described the vehicle that matched the description of the one that you saw video of driving out of the Walmart parking lot, and that Monica Pridgeon very clearly described in her testimony. We know, and you know from the maps that are in evidence and Captain Carter's description, that that vehicle that Markeith Loyd was driving, the Mercury, was found very near from where the Walmart scene was and very near Royal Oaks, where you saw photographs of the shots that were fired. But of course, well, you also know that the 9mm that was recovered at the time that Mr. Loyd was apprehended matched the shell casing, the 9mm shell casing found at the scene at Royal Oaks, a Hornady 9mm, and that the same type of unfired cartridge was found inside Mr. Loyd's car. But of course, you know that he's the one that did it because he told you that he was the one that did it. Now, Mr. Loyd gave you a slightly different version of what happened at the scene of the offense. And we'll talk about that in a moment. Now, you all have photographs that are part of my presentation in front of you, but this is a good time to remind you that every single picture that was admitted in evidence, there's a hard copy of it, and it's going to go back to you as members of the jury. So you'll be able to review every photograph if you choose to do so. So the second element is that, the third element, or the second part of the first element, is that he didn't act beyond just thinking about it. And of course, that act was him firing a 9mm firearm at Captain Carter. Now, that's the appropriate time to address the defendant's claim that he was firing in self-defense. He fired a warning shot, is actually what he said. You know that's not true because you saw the photograph and evidence of the firearm and the projectile striking the hubcap of Captain Carter. More importantly, something that was glossed over a little bit was there's a photo on your screen, AB, and there's a piece of a projectile that was recovered. But next to that projectile are two pieces of plastic, and if you look at them carefully, it's pretty clear where they came from. They came from Captain Carter's hubcap. So when the projectile struck Captain Carter's car, it leaves those marks. And that's important, ladies and gentlemen, because AB is up above, closer to the Mercury vehicle than it is where Captain Carter's vehicle came to final rest. And that's important because it shows you how close Captain Carter got to the defendant at the time. Because remember Mr. Loyd's testimony, he said he fired at the ground, or he thought he fired at the ground. And of course, he did not do so, and could not have done so to be able to hit Captain Carter's vehicle. We also know that Markeith Loyd fired at Captain Carter because of the way Captain Carter described how he parked his vehicle. When he pulled in behind the defendant, he turned his wheels to make sure that he had cover from the vehicle as he was approaching the suspect. So the wheel that is struck, the outside hubcap, is the right front, which would have been exactly the wheel closest to Mr. Loyd, telling us that that Markeith Loyd shot exactly in the direction of where Captain Carter was. So that brings us to the second element. Markeith Loyd acted with a premeditated design to kill Joseph Carter. Now, what evidence do we have of that, and what exactly does premeditated design mean? You've all been read to this morning. I'm not going to read to you again, but you can see it on your screen. But what it means is a conscious intent to kill. And that conscious intent has to be present in the person's mind during the act. So the example I would give you is, all being Floridians, familiar with mosquitoes. You're sitting on your front porch, a mosquito lands on your arm. You look down and you see it, and you have a decision to make. Do you brush it off, or do you smack it? There's a conscious choice in your mind to do one or the other, and it may only take a matter of seconds to make that decision. But if you smack it down, that is an intent to kill that was formed in your mind at the time and during the actual act. And that is all that is necessary to prove premeditation in the state of Florida. And there is no doubt that Markeith Loyd had a premeditated design to kill Captain Carter. How do we know that? We know that because of the way Captain Carter described what he saw when he pulled up behind who we now know as Markeith Loyd. What did Captain Carter say the man in the dark clothing was doing when he pulled his car to a stop? He was already standing, looking right at him. Firearm, remember he told you the firearm wasn't up at that point, but he was standing waiting for Captain Carter. If Markeith Loyd's intention was to flee, if his intention was to scare Captain Carter, he could have jumped out of the Mercury and taken off running. But he didn't. He stood and he waited for Captain Carter yet another law enforcement officer, to start to get out of his car, and that's when Markeith Loyd fired at Captain Carter. We also know, unfortunately, that Markeith Loyd intended to kill Captain Carter because he had just killed another law enforcement officer minutes before for trying to do the same thing that Captain Carter was doing, which was to take his freedom away from him. Go back to the primary instruction. Number 3, basically, is the difference between a completed murder and an attempted murder. All the elements are the same except that Mr. Loyd failed to kill Captain Carter for whatever reason, and in this case is that he wasn't a good enough shot and Captain Carter was able to retreat because he, unlike Lieutenant Clayton, was in a vehicle. And then elements 4, 5, and 6 all really address the same thing, which is that Captain Carter was a law enforcement officer on January 9th of 2017, that Mr. Loyd knew he was a law enforcement officer, and that Captain Carter was engaged in illegal duty. And we know that Markeith Loyd knew Captain Carter was a law enforcement officer because Captain Carter was driving a vehicle with lights and sirens. He had lit those lights and sirens up when he began to chase Mr. Loyd, and of course, because Mr. Loyd told you that he knew that Captain Carter was a law enforcement officer. There is no doubt, ladies and gentlemen, let alone a reasonable one, that that Markeith Loyd is guilty of the attempted first-degree murder of Captain Carter, a law enforcement officer. Now, on the screen, I've referenced that special finding and language from page 39. That's the verdict form that I was referring to that you'll receive. And it's a very simple question. Did the person have and actually possess a firearm? Did he discharge a firearm? So that brings us to the second crime, aggravated assault with victim Antoine Thomas. There's no doubt that Mr. Loyd committed this crime. Mr. Thomas described Mr. Loyd physically. He described his security shirt that he was wearing on the date of the offense. And as you can see on the screen, and you heard in testimony, he picked him out of a photographic lineup within hours of the actual crime. Significantly, Mr. Thomas described Mr. Loyd carrying not just one firearm, but an extended magazine in his other hand, which is exactly what Mr. Loyd was carrying when he went and fled. And of course, Mr. Loyd told you that he was the one that met with Antoine Thomas. Intentionally threatened by act, Antoine Thomas's testimony was that he was on the landing and that Mr. Loyd put the barrel so close that he could reach out and touch it. He could see down the barrel of the firearm. And I would submit to you that that provided an ability to carry out the threat, which is also an element of the crime, and that any reasonable person would not just be in fear but terrified, as Antoine Thomas testified he was at the time. Now, again, Mr. Loyd gave a different version of what happened to Thomas, and his testimony was essentially that it was a godsend vehicle for him at 7:25 in the morning, and that I think he actually leaned up on the witness stand and said he had the guns in his hand. And I would submit to you that that is not credible. It is inconsistent with Antoine Thomas's testimony. But I wanted to point out something else about Mr. Loyd's testimony on that point. Because, and we'll talk about this in a moment, you all had the opportunity to observe Mr. Loyd for an extended period of time. And he's a very intelligent man. And he made it clear, and you heard, that he had studied the evidence in this case very closely. And his statement about what happened with Mr. Thomas was evidence of that. Because he used Mr. Thomas's statements, are you serious? As a way to try to justify and give a story about what occurred. And that should not be surprising given the testimony that Mr. Loyd gave about how closely he looked at everything in this case. But it is inconsistent with Antoine Thomas's statement, who is not charged with first-degree murder and is not a multi-time convicted felon. We've already talked about the other elements, and it's clear, I believe, to you that a firearm is a deadly weapon. So we're going to move on to carjacking. The carjacking of Antwin Thomas. The elements of this closely mirror the aggravated assault charge. The only difference is that they're the taking of a vehicle. You all are intelligent enough to look at the elements of that, and I feel that they've been proven beyond a reasonable doubt. And there'll be a special finding verdict form for that charge as well. Which brings us to firearm or possession of a firearm by a convicted felon. Now, Mr. Loyd testified, and you know from other evidence, that he possessed multiple firearms at the time he had been convicted of a felony and not pardoned. There's a stipulation to that in evidence. And this is a photograph of the .40 caliber Smith & Wesson .40 SVE that he used to kill Lieutenant Clayton, and that you heard evidence and testimony that he possessed on the day of the crime. So, ladies and gentlemen, that addresses all of the crimes that are alleged other than Lieutenant Clayton's first-degree murder, which is what we'll talk about now. So, I want to focus, as I said, specifically on the premeditation that is necessary to prove first-degree murder. Because I would submit to you that the other elements are extremely self-explanatory and obvious from the testimony that you've heard. There's no doubt that Mr. Loyd is the person who committed this crime. He was identified by Takeshia Bryant. You saw video of the man, a man wearing the exact same outfit or clothes that he was wearing. You know that the shell casings from his gun matched the gun that was found at the scene where he was apprehended and the projectile that was removed from Sade Dixon. We know, unfortunately, from the testimony of Dr. Joshua Stephanie, that the projectiles that were recovered from Lieutenant Clayton matched the gun that Mr. Loyd possessed. And you know Lieutenant Clayton was a law enforcement officer from the testimony of Detective Cadis, from Sergeant Thornton's testimony, and the obvious photographs and video of her walking through the Walmart on the morning of January 9th, 2017 in full uniform. So as I told you, we're going to focus on premeditation because it is the only thing that is remotely in dispute, and it goes to the defenses that Mr. Loyd has raised in this case. So let me back up. There are three reasons why we know that Markeith Loyd had a premeditated intent to kill Lieutenant Clayton on the morning of January 9th of 2017, or three categories of evidence. The first one is that he had a motivation to kill that morning. And his motive, and I want to specifically direct your attention to, this is of course just one Facebook post of several, to the second to last line. I'd rather die than live my life in the snow. It is not a secret. There's been evidence that Mr. Loyd was in prison up until 2014, and he's made it clear through his Facebook post he was not going back. Lieutenant Clayton's goal, her only goal on the morning of January 9th, was to bring him into custody. And that was one of the few things he would simply not allow. The defendant had a motivation to kill. We know that Mr. Loyd had a motivation to kill because of the preparation he took prior to ever going to Walmart on the morning of January 9th. We know that he had obtained a bulletproof vest. Right? And this is where we start to intersect a little bit with his self-defense claim. Because if you're fearful of law enforcement, obtaining a bulletproof vest in the event that you want to surrender so that you're not killed during the surrender makes a certain amount of sense. Why do you need and not just one firearm, why do you need two firearms? And not just two firearms, why do you need an extended magazine so that you can carry more bullets with you? The evidence is clear that Mr. Loyd knew well before he ever saw Lieutenant Clayton grocery shopping that morning, that if he came across a law enforcement officer who got in his way, he would kill them. And you all know from the video that that is exactly what he did. You know that because in his Facebook post, he doesn't talk just about defense, but he talks about going on the offensive. When you look at the posts, if you choose, when you go back to the jury room, all of them in their entirety, because I haven't even published them all to you at this point. I've only shown you the ones relevant to specific times and phrases.
Objection.
Overruled.
I have a motion.
I'll see you at sidebar. Mr. Loyd, you will remain silent during this time.